SJC-11813, Commonwealth v. Charles Monroe.
Thank you very much for that.
Ms. Delberg, good morning.
Good morning. May it please the Court, I am Nancy Dahlberg. I'm here on behalf of Defendant Appellant Charles Monroe. I'd like to start by addressing a number of representations made in the Commonwealth's brief with which I take issue. First of all, in claiming that the defendant has waived certain factors to be considered in determining whether his statement to the police was made voluntarily, the Commonwealth misconstrues the burden of proof. Whereas here the defendant has raised voluntariness, it's the Commonwealth's burden to prove beyond a reasonable doubt that his statement was voluntary in the totality of the circumstances. Though the totality of those circumstances include everything apparent on the recording of the defendant's statement before this court for its de novo review, the CD of that interview is before the court, and I can't really emphasize enough how important, although time-consuming, it is to review the actual CD.
Now, there are two different transcripts, it appears.
Yes, and I'm happy to explain that. The defendant had prepared a transcript through a court-approved transcriber for the motion judge. He reviewed that transcript, but and apparently there were some emendations.
Judge Lemire did? Is that what you? Who reviewed it? Judge Lemire.
The motion judge, Lemire. I may be mispronouncing his name. I'm sorry. Reviewed that according to the transcript of the motion hearing. And also watch the CD. So the transcript's an aid. After the defendant filed his brief that's before this court, the Commonwealth undertook to move for a stay and to get another copy of the transcript, or make another transcript as an aid to the court. We had opposed that motion, but it was allowed. And apparently the Commonwealth took issue, well, first alleged that the transcriber who transcribed the transcript below wasn't court approved, but she was. So some back and forth that I don't want to bore the court with right now. But in any case, the defendant's brief cites both the timestamp on the CD, which I think is the most important thing actually, and also cites the transcript that had been reviewed below. The Commonwealth's brief just cites its transcript. The defendant, I have real issues with the transcript that's attached to the Commonwealth's brief, which it put in its record appendix, because for one thing, it doesn't cite any of the silences of the defendant, the times that he didn't answer questions.
So you're basically saying it's only the CD that's really going to tell us what you want us to see.
It's the CD that matters. The transcripts, the two transcripts, hopefully will be an aid to the court.
Did the jury have any of them?
No, the jury, so what we're arguing here is the motion is suppressed. The jury didn't have any, the motion judge had the original transcript of the CD. The jury saw a version of the interview.
But not with any transcript as an aid.
Did the judge see the CD?
Yes. Yeah. According to what he said, he saw the CD.
And the jury saw all or a portion of the CD? Portions
of the CD. A lot of the CD.
So what will we see in the CD that we can't get from the transcript exactly?
Well, you will see the defendant's reaction. Well, first of all, there are some things that are a little hard to hear, and there's some disagreement as to some of the words that are said. Each transcriber, ultimately what's said is up to this court. In terms of what you'd see on the CD is the defendant's reaction, crying, silences, but the reaction to what we assert is very, very extreme threats to the defendant. And there's a lot in there, but these threats fit exactly into the extreme and explicit description that the United States Supreme Court has described, going directly in the circuit court, agreeing to the primordial and fundamental relationship between parent and child. The police repeatedly told this 18-year-old boy that he was going to be the reason his girlfriend lost their baby, that unless he talked to them, she would grow up in some family that she didn't even know, that doesn't know him, doesn't know her girlfriend. They repeatedly, you can only help your girlfriend now, meaning you can only talk to us so the baby won't be taken away from her. There's a reason you attacked these girls, and we want to know what the reason was.
Can I, this is a temporal question.
Yes.
I did not look at the CD yet. I have just quickly looked at the transcript and obviously the briefs. But the question is, some of the most explicit threats, as you call them, as in the one you just mentioned. Mm-hmm. My memory is they occur, but the actual, your client continued to deny and or not answer, and it was somewhat later that he began kind of giving details about some of these events. And so the question really is connecting the most explicit of the threats to what happened, and does the fact that there's time in between and other questions and his continue to either not answer or deny, does that make any difference in your view?
I think actually in this particular case, when you read the transcript, basically if he was silent, and the transcript does help in the transcript that we have does
that was
help
the one
out.
I looked at.
He's silent. Then there is a period of time where they're really going at this hammer and tong, and he's crying, and eventually he says, "I'm going to tell you the truth because I love my daughter." So it's a build-up, but he's quiet. He starts making some admissions. They're going at it, and whenever he stops, it's like, think of your daughter, think of your daughter. And the reason I refer to a drum beat is because you can hear it in the background. It's a drum beat. So he says, "I'm going to tell the truth because I love my daughter," and they say, "That's what we want. You have to think of your daughter. You don't want your girlfriend to lose her either."
But right after that, what does he say?
Well, it's an ongoing, then he starts to talk about this third alleged assault and, sexual. So it's a 2-hour interview. It's back and forth, but it's not one comment. And, even to the point where I don't think you want your daughter living with strangers, going to sleep at night with strangers that mean nothing to her. And it's not one comment. It's over a period of time. And I think, although it is time-consuming, it does show this progression. And just to go back for a minute to his situation, 18 years old, just started a GED program, poor educational background, came from Africa 6 years earlier, tells the police repeatedly that he has emotional problems if it isn't already apparent. I ain't so good, I'm going through emotional problems. And what's their reaction? This is the time to talk to us about what happened. You're having emotional problems? Good. Tell us now.
Over the approximately 2-hour period of the interrogation, approximately how many times was think of your daughter, or how many times did the drum beat land?
Many, and I wish that I could.
20?
20? I'm going to say 20.
20?
And then it could get slipped into something else. I do also want to mention that, from the beginning it's clear he wanted to talk to his mother. He's a kid, okay? He's just turned 18.
Where is that so clear? He says it at the beginning, but there's nobody there.
There's nobody there, but in terms of his vulnerability, where he was coming from, and the voluntariness of his statement, there were actually people there because there's just a curtain in the back and you can hear the police. But let's assume for a minute that these two police officers didn't hear him. They still had an obligation to say, just say, "Oh, you're going to have an opportunity at some point. You have a right to make a phone call," but he was not given any opportunity to make a phone call. And he starts out, in his own mind, he needs to see mom. So in terms of emotional maturity and stability, I think that's a strong indicator. But even at the end of the interview, he says, "Well, can I talk to my mom now?" And they say, "Well, after you do this, this, and this." And so 2 hours has gone by and no one's found it necessary to give him that opportunity. And the other thing that I think also makes this a model of, poor police conduct, is that they say, "Well, we need to talk to you about a warrant." And he says, "What warrant?" And they say, "Well, if you want to talk to us, we'll tell you." And he says, "But but
Yeah,
what
but they're in the
warrant?
middle of, aren't they in the middle of, reading him his Miranda rights when that happens?
It was before they gave him his Miranda rights. They say, we want to talk to you about a couple of incidents and a warrant but first we have to tell you about some rights. And he says, what warrant? I don't know anything about a warrant. And then they start again. He said, but what warrant? And there's a statute. The legislature thinks that when people are arrested on a warrant, they're told what it's for. They're very clear from their language. We're not going to tell you what it's for, what it's about, unless you want to talk to us.
The warrant was related to these incidents.
Yes.
There was no
Right.
separate warrant for some
No, but
other.
apparently there's an additional second warrant, because these are 3 cases
Right.
over this very short period
But
of
they all
time.
relate to this. It's not some separate alleged crime.
Not, the record doesn't reflect that at all. He's arrested on a warrant from one of these incidents. And then after they get him very quickly to sign the Miranda.
Well, but, I don't know. I'm reading this transcript, and maybe that's the problem. It's the transcript, but they tell him, okay, we want to talk to you about a couple incidents because before we talk to you, we have to advise you of some rights. And they started advising him of rights, and he's answering that he understands these things. And he says, having these rights in mind, do you want to talk to us? And then he says, about what warrant? That's when he mentions the warrant. And they say, well, wait a minute. Until you answer this, I'll explain it to you if you want to speak to us. And he said, then I don't understand but do you want to talk to us? I mean, they've just read him his Miranda rights. They've just asked him if he wants to talk to them. You can understand why they don't want to start getting into a substantive conversation where he could say something before. I'm on record appendix 73.
Okay, well, yes, 73. So he says about what warrant, and I apologize. They had gone through Miranda rights. But he hasn't signed anything.
No, but why would they want him to start talking until they had ascertained whether or not he wants to talk to them? I mean, that's the road to perdition
They're
for the
required by
police.
statute. In fact, they're subject to criminal prosecution if you're arrested on a warrant. You get to say, what warrant am I being arrested on? What am I being arrested for under the statute?
So your point is they had an obligation to say, here's the warrant.
Yes.
You don't disagree, though. Had they done that, they could say, we're not saying anything more about it until you answer, tell us whether you want to talk to us.
Yes, but under the statute, they do have an obligation to say what he's arrested for and to show him the warrant if he asks. That's one piece of this, but it's part of a whole. The police knew that the defendant's relationship with the 2-month-old baby who he has in his arms when he's arrested, and they ask him about her, and they continue to bring up DSS, and his reaction to these things, and the importance of watching the CD is to see how he does react. He's emotionally, very psychologically stressed by this. This is very much like Tingle and Lyman, and I think if we were to take ourselves out of this particular situation and say that, yeah, someone was threatened that the daughter would be taken away and grow up with strangers and no one in the family would ever see her again, would consider that extreme and explicit. And it was false. There was no legitimate basis for this.
Was the issue of voluntariness a live issue at the trial?
Well, the motion to suppress had been denied.
Right.
The CD was shown.
But was the issue of voluntariness a live issue?
I can't say that it was at trial.
Okay.
I think that the defendant would have felt that there was very little to be done with that at the time because of the admissions made. And again, in terms of the Commonwealth's brief, its primary assertion that the defendant cleverly tailored his statement to fit the evidence about which the detectives told him while avoiding criminal culpability isn't supported by the record. He made numerous admissions, which fed into, I think, the strategy at trial. And in addition, the Commonwealth statements of facts assume...
What was the defense at trial?
The defense at trial, well, essentially, he admitted to issues to do with the robbery. He didn't testify. So it was cross-examination, and the jury acquitted him on the aggravated rape charges and one count of ABDW, or ADW, I'm sorry, I would have to check on that. I do want to point out that the Commonwealth Statement of Facts assumes that all of the testimony it presented was undisputed, when in fact the defendant was acquitted of certain charges So I do want to point that out because it's not fashioned as this was the Commonwealth's evidence. There are certain facts certainly that the jury didn't believe. I was also somewhat puzzled by the Commonwealth's discussion of some of these issues under a substantial risk of miscarriage of justice standard on the voluntariness case because that was not part of the mix. And as to the second issue, I'll rest on my brief unless there are further questions.
Great, thank you.
Thank you.
Good morning. May it please the court. My name is Donna Rosemeyer, Assistant District Attorney representing the Commonwealth. I would suggest the motion judge correctly denied the defendant's motion to suppress, where looking at the totality of the circumstances, looking at the whole interview, I would say, correctly found the defendant's statement was voluntary.
You're not suggesting, however, that the questions or the statements regarding the daughter were proper, are you?
No, I'm saying they occurred at the beginning of the interview.
They occurred really, they were sprinkled throughout.
I would disagree with that. I would say they occurred towards the beginning. I counted 6 times. I actually counted for my own purpose.
Counted more than that.
I can tell you on my record appendix 20 to 25, and one time on page 55 they mention it, and that was it. Nonetheless, I would say the judge correctly determined, as he astutely recognized, the defendant was able to tailor his statement to fit the evidence, which the detectives were telling him, and while minimizing his capability. And this is seen, he never admits to the rape. He always says it was consensual, that he met her, and within 5 minutes she gives him oral sex. He maintained that throughout. He repeatedly denied having a knife and using a knife on victim 1.
Let me go back to your earlier point. If you're wrong about how often this matter was harped on, do you lose?
No, I don't, because again,
because
if you look at the
because I think you're plainly wrong. I mean,
well, we can
page 92. This is your opportunity. You're probably going to end up. You're not going to see that 2-month baby for a long, long time. 93, you're going to be the reason your girlfriend loses that baby. 94, you're going to be the reason your girl loses that baby. 95, think of your girlfriend, think of the baby, think of your parents. 97, you're just helping your girlfriend, your daughter right now. 100, biggest one you're helping right now is your daughter. 118, I'm going to tell you the truth because, 119, you have to think about your daughter. You don't want your girlfriend to lose her. That's over the course of 30 pages.
Yes, that occurs at the beginning.
And I don't claim to be comprehensive.
Well, you can see the video and you can judge it by the video itself. I would suggest it occurs at the beginning of the interview, and then as they go on to the later part of it, it is not mentioned again. But regardless, my argument's still going to be the same. And it's clear, as the judge found, it didn't overbill the defendant's will. He clearly gave exculpatory statements. He repeatedly denied having a knife, repeatedly denied knowing the knife, where the police, as we learned, seized the knife under his bed. He repeatedly denied any sexual contact at first with the third victim, and it's until the police say, you're semen, as we found semen on her.
Hold on, just on that point. You say in your brief the police said that he had his DNA. It was on the same day as that incident. They could not possibly have known it was his DNA.
They know from the victim's statement that she says he raped her, and they know she was brought to the hospital, and they know there's semen. I think they can say that's his semen.
I don't.
I believe, and as it turned out, as we know at trial, it was his semen, because the DNA came back him. I would suggest that he first denies everything, and then they say, we have you on videotape, we know you with the girl. What girl? What are you talking about? And then, okay, well, I know her, I came and I met her. I would suggest clearly looking at the tape and the totality of the circumstances, balancing it. I think it's clear.
Well, if he's denying everything at the beginning, how does that explain what the police did talking to him about the daughter? I mean, that's when he starts to admit to things,
that's,
right?
if you look at, no, he doesn't, actually. His next statement after that the culmination, you want to look at all those pages, the next statement he says is, what backpack, what girl, what are you talking about? And then I believe his next statement was, it was no sex, I didn't do no sex on them, I didn't touch the girls, I love my girlfriend, and he continues on in that vein. And then they say, Charles, listen, the girls have identified you. And that's when he starts, well, what girls, where? And they start talking about the streets. And then he starts with the third girl. Well, okay, you're caught on videotape with the third girl. Okay, well, I did meet her up with her. And then they start talking about that. And it's clear when he starts giving it is when the detectives start telling him what evidence they have. And I think even if you say how coercive this was, he never fully confesses. He always has an explanation, and I think that benefited him at trial because it gave him, without having to testify,
So does he have to
defense.
be broken completely for the rule to apply?
I think the rules, you look at the totality of the circumstances and the fact that whether his will was overborne, and that's what you look at. And I would suggest his will definitely was not overborne if you look at the whole statement in its entirety, and you look at the manner, you look at the way the police officers were talking to him, and you look at how the responses he gave. I would suggest if you look at the video, it's clear in the totality of the circumstances, as the motion judge found, his will was not overborne, and thus his statement was voluntary.
What do you make about the way he is at the end, which is kind of a wreck?
I believe I would not characterize him as being erect. He did get emotional. He did put his head down and cry. But I think the law is whether he's, and this is
When
clear.
are we looking to see if his will has been, is that not also something to see whether or not his will has been overborne?
It's one factor to look at, but when you look at emotional, you look at whether he's acting irrational, and I don't think anywhere on this tape the
You say
defendant...
emotional equals, it has to be irrational to count?
I would say, yes. Claire in LeBlanc said the fact that you're emotionally upset itself doesn't render a statement involuntary. It's whether there's evidence of the defendant was acting irrational.
But that's a problem for you, because it may be rational for somebody who is told that if they do not speak to the police, their child is going to be taken from their mother. So the fact that he is trying to protect his child from being taken from his mother is rational. Does that make it voluntary?
If you look at the totality of the circumstances, well, first going back to the DCF, we don't know...
Go back to my point. I mean, the problem with it is that when they say to him, if you don't talk to us, you are going to be the cause of your child being taken from your mother and being raised by strangers. So it is rational then to attempt to talk to them in the attempt to prevent that from happening.
And it shows rationality, you giving excuses, you giving exculpatory statements to help yourself out. I believe that shows a rational mind that's not overborne by pressure.
Even if the rationality is part and parcel of you would admit the false statements by the police. There was nothing there was no connection between whether or not the mother loses the child and what he was to say to them.
What we do know, I don't know on the record clearly whether it's a false statement or not. What's on the record is that DCF has an open case against him. He's been going to his girlfriend's apartment on Jefferson Street, which is important because that's the area which the third victim was sexually assaulted.
How does that relate to whether he tells them the truth or not?
To be honest, I don't know, but I just don't want to say it's a false statement because there's an open DCF case. He's not supposed to be...
She may lose the child, but not because if you don't talk, your girlfriend's going to lose the child. That bears no relationship to whatever DCF is doing, does it?
I don't think so.
Let me ask you this. They repeatedly say, we have you on tape, we have you on tape. Is that true?
Yeah. On this record... Were
there tapes admitted at trial?
I mean, it's not on this record. I can tell you it is true, but it's not on this record.
Okay, but they were admitted at trial?
No.
Oh. No, that's strange.
Well, when you say
But there's
on
been
tape,
no allegation of false evidence.
fine.
I can say it that way.
Okay,
It's not on the record what occurred with the tape.
All right, thank you.
what tape are we talking about?
He's caught on surveillance tape with the third victim because as she's walking to school, they go by a restaurant and they said, you've been caught on surveillance on that. And they tell the street in the exact corner of which he was. And that's...
Okay.
I would suggest when he first starts saying, okay, well then, shows his mind working. Okay, well, I do know her, I met her, she was my friend, I thought she was my friend. I then went up to her, I said, hey, and then they talk about going to the house, and then her giving him a ride, and he does that whole story about that. And that's what we get into that.
The police also say fairly early on, this is going to be your only chance to tell us this. You're in a lot of trouble right now, and we're going to give you one opportunity to talk to us and tell us why this happened, and maybe some of the stuff has been consensual. That's not exactly in accordance with what we've said should happen.
You're allowed to say it's your chance to talk to us. Maybe
your one chance.
That's, yeah.
Well, any impropriety in that, again, I would say looking at the totality of the circumstances.
Well, now we're sort of adding up a lot of improper things. So doesn't that count into the totality?
It does, but I suggest if you look at the whole interview as a whole, as the motion judge found, who also viewed that. I know you look at it yourself, so you can decide it on your own, but I would suggest no, it didn't overbore his will. Regarding the right to a phone call, my point with when I argued waiver is that when you bring a new claim up on appeal saying he wasn't afforded his right, and even right now saying, well, the police behind the curtain, There's no record below, and the Commonwealth's not giving an opportunity to explain, well, did the police officer hear him say, can I talk to my mother, at the beginning of the
But
interview?
you know it's the totality of the circumstance, and it's your burden.
Not when you don't raise that my right to a phone call was violated, when clearly on the record he's advised of his right to a phone call. So my point in saying waiver is that the Commonwealth, looking at Munda, is not giving an opportunity, because had we known, they raised this below, that she's alleging they heard him say, I want to talk to my mom at the beginning of the interview, we would have been given the opportunity to put the two police officers on and ask, did you hear him say that? And by the way, the curtain is the curtain to the window, not to where the police officers are standing.
I thought the argument was less on, I mean, your point is well taken, that there is no evidence that they heard it. So I think what Ms. Dahlberger was saying here was it shows his own, forget what they knew or didn't know, it shows his own emotional circumstance. That was, which is a different point.
Okay. On their brief, I took it as a separate point, that they violated his right to use the telephone.
That is in the brief, but I don't think it hinges on that particular point. I think it's more how long it was and, sort of adding up all the stuff.
There's no further questions.
Thank you, counsel.
Commonwealth rests on its brief. Thank you.
Thank